That's lovely. Let's make a start. So good afternoon, everyone. Really pleased to welcome you on behalf of Equality, Diversity, Inclusion, which is a part of the Bushra Ali Group. A huge thank you to both Emma Rutherford and Adam Pike today from the number 8 chambers, both from number 8 chambers that are presenting on COVID-19 related issues, policy procedure and updated case law. So that we can maintain good quality in sound and picture, can I please ask that everyone keeps themselves muted in terms of audio on your Zoom, and also to keep your own video switched off. That's important because we will have quite a few people on this session so that we can maintain good quality audio and sound also. Please note this session is being recorded and will be available on Adam Pike's YouTube channel, as well as the Bushra Ali Group channel later on. Feel free to post your questions using the chat box throughout the session. And once both speakers have presented, a selection of those questions will be put to the speakers. I will continue to allow people in, and it shouldn't cause any interruption at all, but if we just keep ourselves muted, and obviously the speakers will have their video on whilst they're presenting as well as their audio. So I'm going to switch my video off for you, Emma, and then do you want to share your screen now so
Yes.
we can get your slides over?
I think you'll need to take yours down before I can do that, if I remember from last time.
Let these in, let's have a look. So stop show, no. Are you able to get your screen up now?
Yeah, there we go. And we will, bear with me a second while we start slideshow. There we go. Right, excellent. Well, good afternoon, everybody. I'm obviously doing an update on COVID-19 policy and procedure. I'll start with a little bit of a health warning. My notes are accurate up to, well, yesterday when I last looked at them. It is obviously a fast-moving situation, and there are changes and have in fact been updates to the notes since I did this session last Thursday. So I'll give you the most up-to-date information, but with that caveat that things are changing and changing quite rapidly with the situation. And who knows what will happen next week with whatever's going to happen next. Right, overriding principle from the Home Office is that the Home Office and its ministers are very clear that no one should have a negative outcome through the immigration system due to a circumstance that was beyond their control. So the position that the Home Office are apparently taking is that you shouldn't suffer because you couldn't comply with something because of COVID-19. In reality, I think there are some difficulties that we'll come to later on and gaps in the provisions that they currently have, but it may be that those get remedied at later dates. I've just put on that introductory slide as well for you, the contact email address for the help desk and also the telephone number. I understand getting through on the telephone number is a nightmare, but those are the details there for you should you need to contact the Home Office about anything. Right, we'll start with visa extensions, because this is where the policies really start from the Home Office. Back in February, Chinese citizens who are in the UK were told that they would get an automatic extension to the 31st of March 2020 if their visa had an expiry date between the 24th of January and the 30th of March this year. You had to have been compliant with the conditions of your visa prior to the outbreak, and it was only for those who would have left the UK but couldn't do so due to the virus. So predominantly one can envisage that's going to help visitors, students, maybe people at the end of work visas who always intended to return home. You didn't have to do anything as a Chinese national, your visa was just automatically extended. I think there are some legal issues with that, but that's the position the Home Office have taken. Non-Chinese citizens who ordinarily live in China and are obviously non-EEA nationals, because they wouldn't have any difficulties, got an extension of leave if they contacted the coronavirus hotline. So they had to take steps, but again, the same provisions were in place for non-Chinese nationals who live in China. Obviously, we went into lockdown on the 24th of March, and of course, by that point, there were significant problems in travelling to numerous countries, because numerous countries had closed borders, there were flight restrictions, there were huge problems by then in travelling. So the policy was extended to all nationalities, and the period of leave is now extended up to the 31st of May 2020. Obviously, that date may change again as the situation develops. This extension includes those covered by the previous extension, but it is now not an automatic extension. There is an online form which is easy to find on the Home Office website that needs to be completed with pretty basic personal details, Home Office reference numbers, visa reference numbers and the like. And then you need to give an explanation why you cannot leave. It's not just going to be a given that you can't leave. There are obviously flights to some countries. If you're having to self-isolate, then obviously you can put that down as your reason. The other example obviously given is travel disruption. And even though there are some flights going, of course, you may not be able to get on those flights, but you do have to provide your reason. Within 5 working days of you telling the Home Office that you can't leave, you should get a confirmation from the Secretary of State that she's extending your leave to the 31st of May 2020. It is fair to say that the legal basis of all this is a little unclear. One of the issues I think may have been resolved by the fact she is now giving you written acknowledgement that your leave has been expired, but there are, I think, some issues with 3C leave and whether it is in fact extended if you're applying for this extension after your leave to remain has expired, or you don't get the confirmation before your leave to remain would expire, because by filling in those details, you're not really applying for anything. So I'm a little unclear as to how Section 3C works. But of course, there are, let's just go back a moment, there are of course very real benefits in having your leave extended and then filling in the online form. Firstly, you shouldn't be treated as an overstayer, and that obviously has implications for future immigration applications that you may make. You shouldn't be penalised because you couldn't leave. You should, if you're working, still be able to work, and your right to rent continues as well, which could be quite important for someone who perhaps is here as a student. So it is important, if you've got clients who are going to be caught by this, that you do tell them to complete that online form. But I reiterate, it is only for those who intend to leave the UK once they are able to do so. If your clients are wishing to extend their leave further, they need to make the correct application. One little change that's arisen in the last week, there were a number of people and a number of queries from people about clients who'd been issued entry clearance already, but had been unable to travel due to the current situation. Last week, the Secretary of State has confirmed that those with 30-day visas to travel to the UK for work, study, or to join family members whose 30 days has expired or is about to expire, can request a replacement with revised validity dates free of charge, and that will continue until the end of the year. So there's plenty of time for people to make arrangements in order for them to travel if they've missed their window or are going to miss their window, because I suspect even when we get back to some form of normality as a country, there are still going to be issues with ability to travel and difficulties in getting flights. Important to note, in relation to applications for further leave to remain, there are no concessions at present regarding meeting the requirements of the immigration rules. And I can see at least 2 obvious areas, certainly in relation to family members, where it may be difficult to meet the requirements of the immigration rules because of COVID-19 related issues. The first relates to the minimum income requirement under Appendix FM. Obviously, you have to show you've been earning a certain amount for a set period of time. If your income has reduced because you're self-employed, because you're not working as much, you've been furloughed, so you're only receiving 80% of your normal salary, that may well affect your ability to meet the immigration rules. And it does seem rather unfair to me, to those who are caught by that, to then be unable to meet the financial requirement because of COVID-19 related issues, especially if they have gone back, their earnings have gone back up once the situation has resolved. Rather seems to fall foul of the promise that ministers have given that nobody should lose out into the immigration system because of COVID-related issues. The other one that occurs to me is English language requirements. You can't presently do a test. Same would apply to Life in the UK tests. There may be a way around that under the rules, in that the rules do provide that you can say, well, there are exceptional circumstances why I can't meet the requirements. And I think another way potentially around that problem is to say, well, I undertake to take a test as soon as I can, at the appropriate level. Please don't decide my application for further leave to remain until I've done so, and I will submit evidence it's booked as soon as I can. It wouldn't necessarily apply to those with entry clearance applications, because it's not going to be able to travel until such time as they can complete the test and we're out of this situation. So they'll be able to complete the English language test, one would have thought, and hold off making their application. But for those in country who have leave to remain coming to an end, they need to get those applications in to extend their leave to remain. And I think the answer is to take the two-pronged attack there. But again, it does seem a little bit harsh to say there's no concessions when dealing with those two issues in particular. One area where there is a concession to meeting the rules, one could suggest, relates to switching. You'll be aware there's a number of categories in which you can't switch in country. Tier 4 students, for example, can't switch to Tier 2. If you're here on a short-term visa, you can't switch to Appendix FM categories. Adult dependent relatives who are here on visit visas may be able to take advantage of this, because they obviously can't make applications in country within the rules, but you now can switch in country where previously not allowed to do so. Obviously recognising that you can't leave to make your application from abroad at the moment. However, your current leave at present must be due to expire before the 31st of May 2020. You can't sneak an application on the 30th of May for someone whose leave expires on the 5th of June. At the moment, it will not apply to them, but it's very much a watch this space and that date situation, I think. Still required to meet all the requirements of the relevant immigration rules, and you'd still have to pay the normal application fee and the immigration health surcharge. I think the issues relating to Section 3C aren't going to be an issue here, because you've made a proper application, so your leave should be extended under the terms of 3C. There's been a lot in respect of NHS workers, and a lot of information and a lot of provision made for them, and rightly so. And the government has indicated that there's an automatic 1-year extension of leave to remain. Initially, this covered doctors, nurses, paramedics and their family members. It was last week expanded to a much wider list of frontline workers, which is available on the Home Office website. It covers people such as midwives, pharmacists, biomedical scientists, dentists. There's a whole host now of jobs within the NHS that are now covered by this extension. It applies to those if their leave to remain expires before the 1st of October 2020. They will not have to pay a fee, and there's no immigration health surcharge to pay, and that applies to family members as well, as I understand it. It will be up to the employers, so the NHS trusts, to notify those who are eligible. Obviously nothing wrong with asking the question. And then what will need to happen is your biometric residence permit needs to be sent to the Secretary of State, and you'll get your replacement with your new leave, the date the leave expires upon. There's been a further update on the website, which confirms that if you'd already applied, contact the UK VI NHS team to withdraw your existing application and apply for a refund, because there will of course have been those who very recently applied and would have benefited from this extension. It does say, however, you can't do this if you provided your biometrics. I think that may need to be looked at by the government, because it does seem rather unfair to me that you can't withdraw your application, paid for application, and get your automatic extension because you applied in time and your biometrics were taken. Whether there'll be any change there, I don't know. For the avoidance of doubt, because there was some initially, this applies to anybody who's here, whose leave entitles them to work and who works within the NHS. It is not limited to those who are here on Tier 2 or Tier 4 students who are working within the NHS. It covers everybody. So if you're here as a spouse, allowed to work, you're working within the NHS, you are covered by this. Couple of other just little points about NHS workers. There's now no restrictions on the number of hours they can work or volunteer if working within the NHS. As a doctor, nurse, paramedic, I think that has been extended. I mean, that's also been extended as well. I missed that when I was updating the notes. So it's all the categories of frontline workers if they've got leave in those particular categories that are on the screen there. And for pre-registration nurses, they've got longer to take the exams that they need to take, and they've got till the end of the year if they need to pass those. Tier 1 entrepreneurs is another category where there's been some tweaking by the government to assist those who've been affected by COVID-19. It's been recognised that a number of people will be affected, will have had their businesses affected by the current situation, may well have had to furlough staff, may not have the ability to employ people in the way that they did, and they shouldn't be affected or adversely affected by the COVID-19 outbreak. The Home Office have said that they no longer need to employ at least 2 people for 12 consecutive months each. The 12-month period can be made up of multiple jobs across multiple different months. So recognising that there may be people who have lost their jobs during this period, and therefore it affects whether the Tier 1 entrepreneur is in a position to demonstrate 12 months consecutive employment. The time when employees were furloughed, however, will not count towards the 12-month period of employment. So it's really important to be aware of that. You can't just think, oh, well, I've got employees, they've been furloughed, it doesn't apply. No, there will be a break there. So the second of those bullet points will help people affected by that, hopefully. They're not getting rid of the requirement, however, to employ staff for 12 months in total. But if you've been unable to do so because of the current situation, the Secretary of State will allow people to temporarily extend their stay to allow them time to meet that requirement. And this will continue for applications made after the 31st of May 2020. Clearly, there's a recognition from the Home Office that there is likely to be a number of people who will make applications later this year, maybe into next year even, who are going to have their applications adversely affected by the current situation. So at present, there's no time limit on when you make your application, whether you can rely on these provisions. What you will have to show, however, is that your business was disrupted due to COVID-19 and not due to other reasons. There's quite a few changes for Tier 4 students. I'm going to skim over this quite quickly in the changes for sponsors, because I think people will also be quite interested in spending a little bit of time dealing with the changes within the tribunal system, and a couple of other discrete areas that I want to cover in a little while. For Tier 4 students, a number of changes. Distance learning is now allowed. You can start your studies even if you haven't travelled. There's no need for sponsorship to be withdrawn by the Tier 4 sponsor. People whose leave expires between the 24th of January and the 31st of May who wouldn't have been able to extend in country can do so. And where there are problems in completing your course of study within the current period of leave, you will be able to apply for further leave to complete the course. And if there's a problem with you completing your course as a result of COVID-19, so for example, where teaching has been entirely suspended, and in some courses it will have been, you don't need to show academic progression. And if you've had to reset an exam because of ill health, problems that you've had with online distance learning, those will be considered and you will be exempt from showing that academic progression. One very other important extension here is that the extensions for leave to remain from, so let me go back slightly. Students applying for extensions leave to remain from the 21st of March, they don't need to register with the police at the moment, no need to register change of circumstances, limitations on working hours are lifted, and those whose sponsor has suspended all study can currently work full-time. They'll be treated as if they are on holiday and during the holiday periods. And they can volunteer as NHS volunteer responders. So just something to watch out when doing extension applications, that those issues may crop up and they shouldn't prevent any extensions or cause any difficulties with extensions. An important point that may catch a number of people out is if a person needs an extension because they haven't completed their course within the usual time period that they'd be allowed as a Tier 4 general migrant, the Home Office may apply a discretion. So if you've got somebody who's been here studying for a bachelor's and master's degree, haven't been able to complete it, they're up to the limit, they can apply for an extension, but there is no guarantee at the moment they're going to get it. I don't know how comfortably that sits with the undertaking from ministers that no one will be adversely affected, because clearly if you can't complete your master's degree within the time period for reasons beyond your control related to COVID-19, and you're told you can't have your extension because it takes you beyond the normal time period, that does rather seem to me so you've been very adversely affected by the COVID-19 situation. And just a quick note, the graduate route is still scheduled to start summer 2021, so there's no changes envisaged there at the moment. Just a few points on short-term students. They can now switch, they can switch their courses, and they can apply in country to switch unlike the previous provision. And if their leave to remain is due to expire before the 31st of May, they can have an extension to the 31st of May to assist them. Just briefly on sponsors' duties, there are quite a few changes. They mainly relate to reporting and when you can start employing or allowing people to study. But there's no need to report absences related to coronavirus. You don't need to withdraw sponsorship if, because of coronavirus, a student's unable to attend for 60 days or an employee is absent from work without pay for more than 4 weeks. People can start their courses via distance learning from abroad. There's no need to withdraw their sponsorship, and you don't need to inform the Home Office that you've moved to distance learning, unlike in the past. If a student's permanently withdrawn, though, for other reasons, or defers their studies, or just simply isn't engaging for reasons unrelated to COVID-19, you must, of course, report that as usual. You can start their studies if, so that's the next screen, forgive me, I'm jumping ahead slightly. If you've already issued a CAS or a certificate of sponsorship and the applicant has not yet applied for a visa, they can still do so. The start date obviously may well have changed. That will not be automatically refused on that basis and will be considered on a case-by-case basis. And there's just a little bit of assistance for students with English language certificates there as well, that they can have, the universities can self-assess students, or higher education providers can self-assess. Students can start their studies before visa applications are decided if they're studying at a Tier 4 sponsor, a CAS has been assigned, and they've made an in-time application to extend. And the course they start is the same one that's on their CAS. Reporting responsibilities on the university or higher education provider start from the date the CAS is issued. And of course, if the application is unsuccessful, then studies must be terminated. Very similar provisions for employers in relation to not having to notify that people are working from home. Again, employees can start work before applications for extensions have been decided. If they've got a certificate of sponsorship, if they're making an in-time application, and they're employed in the same role as the one on their certificate of sponsorship. But again, reporting restrictions start from the day you assign the certificate of sponsorship in those circumstances, not the date the visa is granted. And any changes that will impact on the application should be updated on the certificate of sponsorship. And of course, if the application for the visa is ultimately unsuccessful, then of course you can't continue to employ them. Importantly, from an employer's point of view, you can use the furlough arrangements, provided that any changes to earnings are part of a countrywide policy and to avoid redundancies, that all workers are treated the same, that the changes are temporary and the pay returns to previous levels once arrangements have ended. Something to bear in mind for people applying for extension applications in the future, that, you know, they shouldn't be penalised for the fact that their earnings for a period maybe dipped below the minimum income they were supposed to earn in that job. And just a quick note for employers, you can do your right to work checks remotely for the time being. You will of course be required to then see the physical documents once the social distancing measures come to an end. Right, a couple of discrete topics I wanted to cover: immigration, detention and bail applications. And in relation to that, there's no plan for wholesale systematic releases of immigration detainees. 350 people were released in mid-March from immigration detention. but the Home Office have signalled they are not intending to systematically release others. There was a challenge by Detention Action in order to secure the release of all immigration detainees. That was rejected by the High Court. During the course of that, there were various commitments made to safeguarding detainees in detention in relation to being able to socially distance, hygiene standards, and being able to get access to medical treatment. The Home Office indicated they were undertaking to proactively review the detention of all immigration detainees. It was indicated that was due to finish around the time that the matter was in the High Court, and there was in fact a letter a day or so ago from the Home Office to the First Tier Tribunal, which did indicate that that review had been completed. It was indicated in the Detention Action proceedings that there was a very strong presumption against new detentions for people who would be removed who would be going back to approximately 50 different countries, all manner of different countries in there. Albania, Nigeria, Pakistan were in there. There's quite a long list, and it reflects those where it is difficult at the moment to remove people. But it is important to note that there is no blanket policy of no enforced removals at present. There's no voluntary assisted removal at the moment, but there are still enforced removals going on. And in this letter that was sent to the President of the First Tier Tribunal earlier this week, it was indicated that there have in fact been removals to Poland, for example, and an indication that there are steps to remove certain people from the country to certain places, and that there's not an impossibility on removing people to all countries, and that where the Secretary of State can remove people that she deems that are inappropriate to be in this country, she will seek to do so. How realistic that is another matter, but it is important to note that there is no absolute ban on removals at present. That said, bail applications are being looked on very favourably by judges, which appears to have been the motivation behind this letter that was sent to President Clements, because the Home Office is getting very upset about the number of releases on bail. He did point out to them that it's a matter for judges. The judiciary are independent and they're applying the law and guidance as they stand. But the Home Office nonetheless are obviously worried about this. That said, there is, and I think from those who I know in chambers who've done bail applications, they've found that judges are looking on them very favourably at present. Judges are triaging them. You may well find in a bail application at present that you'll get a minded to grant notice. So when the judges looked at the papers, if they're of the view that this is someone who can safely be released on bail, they'll indicate that to the parties with the proposed conditions and asking for views. It's clear from the response from Mr. Clements that the Home Office are not really engaging with that process and not really considering their position in light of the tribunal's position, and just effectively renewing applications to keep people, resisting applications, I should say, for bail on the basis of the same facts, and not really engaging with the judge's view, which is obviously it's frustrating for the First Tier Tribunal. But if the Secretary of State does maintain their position, or there is an issue with conditions because you think there's an issue that your client can't comply with that condition or it shouldn't be imposed, there will be a hearing listed. Just quickly, some points to consider in bails. Despite the lack of blanket ban on removals, the reality is to most countries there are no imminent removals likely. There's arguably a very low risk of, or a lower risk of reoffending at the moment because of the restrictions that are on all of us and the higher police presence there is about, and also a lot of people have concerns about their own health and for that reason alone are remaining at home in accordance with the government's guidance and the regulations. And it may be that you have an applicant for bail who does have particular risks in relation to COVID-19. The judge is entitled to take into account further matters when considering whether to grant bail. It's not just the risk of removal, risk of absconding, risk of reoffending, and they can consider the matter. So if you've got someone with other comorbidities, particularly an elderly or vulnerable client, the judge may also be favourably disposed to granting bail on the basis of the COVID-19 risk. Just on a point that arose in a criminal matter I was dealing with in a bail, judges haven't been particularly open, it would appear, to accepting that the COVID-19 situation is a change in circumstance. But what I have noticed is they are willing to accept that because of the COVID-19 situation, there is a change in the sense that people are not getting decisions, cases are not being progressed at the same speed, and cases that would otherwise have been concluded have not been, and they've been more willing to go along that line than just the COVID-19 situation. I think they're wary without guidance from the higher courts of going down that route. Just since the 17th of March, there's no need to report if you're on immigration bail. Those restrictions have been paused. You'll be advised by text message, or your client will be advised by text message when reporting is to resume. It's a good idea to just make sure that the reporting centre where you are to go to has your up-to-date contact details. That can be done by just emailing them your contact details to make sure that you don't miss a notification when reporting resumes. In terms of no recourse to public funds, this is perhaps another slightly thorny issue that's arising because of the COVID-19 situation. There are a lot of people who've been granted leave to remain over the years, especially under Article 8, where there's perhaps children affected, who have this condition on their leave to remain that they're not allowed to access benefits. The government have been clear there will be no blanket policy change to the no recourse to public funds restrictions. I understand that there has been a High Court challenge in the last day or so to that. I don't know what the outcome of that is yet. I don't think we have an outcome. Where it's being suggested, as I understand it, that the entire policy is unlawful in light of the current situation. I don't know how far that's going to go, but worth just keeping your eye out on that. There have, however, been some concessions from the government in respect of the no recourse requirements, and you can access certain forms of benefits, so testing and treatment for coronavirus. If you are particularly vulnerable, you can have the shielding, you can have the food and medicine deliveries, you're entitled to your statutory sick pay, you're entitled to contributory employment and support allowance, and the job retention and self-employed income support scheme, again, they are open to those who have no recourse to public funds endorsements. There's no issue with them receiving any of those. If, however, receipt of those benefits is not going to be sufficient because perhaps you've lost your job entirely, then you will need to apply for the restriction to be lifted. There's an online form to be completed, and you need to show that your financial circumstances have changed since being given permission to stay, and you're no longer able to provide food or housing for yourself or your family. You've got a child at risk because you're on a very low income, or you've got financial problem or had financial problems when you first applied but didn't provide the evidence and you now wish to do so. The people making the decisions, the team making the decisions, have been given guidance instructing them to be sympathetic and to be expeditious in making decisions. How that will play out in practice, I don't know. They're not known for being particularly sympathetic, but they have been directed to be so at present. There are, however, consequences of having your no recourse to public funds requirement lifted. You need to be aware of this. If you're on a 5-year route to settlement under Appendix FM, you will be transferred to the 10-year route to settlement, and you can't, well, you can transfer back to the 5-year route to settlement if you wish to do so, but you will be starting again with accruing that 5-year route to settlement. You can't aggravate the 2 periods. Again, one wonders how that fits in with the overriding principle from the Home Office, that ministers, I should say, that no one will be adversely affected by the coronavirus situation. But nevertheless, that is the current position. So clients need to be aware of that and make an informed decision on that. Now, the final topic I'm going to cover is tribunal procedure. It's all a little bit up in the air. We are supposed to be having further practice directions from the first tier tribunal, which have been held up in light of a legal aid issue, and I suspect because of problems with the Home Office as well. But on the 19th of March, we did have a pilot practice direction issued by Sir Ernest Ryder, the President of the Tribunals, which applies to all tribunals. And it effectively enables the tribunal to deal with cases on the papers, to give a preliminary view. Parties will be notified and cannot be dealt with on the papers without the need for a hearing. But it's clear from that practice direction that where a hearing is required, if it is possible to be dealt with remotely, it will be, but you will get a hearing if you do need one in accordance with that tribunal practice direction. There are daily updates coming out of HMCTS. Sometimes we have updates that relate to the first tier tribunal procedure, and this is the operational update as present for the first tier tribunal. As I'm sure you all know, all face-to-face hearings have been suspended until further notice. It does say other than in exceptional circumstances. I'm not aware of any that have taken place. You'll get a notice with next steps in your case, and cases are being worked through in effectively list order. Bail applications are still going ahead and are being prioritised. They are taking place by telephone. I don't think they're taking place by Skype at present because the Home Office don't, as I understand it, have the facilities for that to happen. Just a brief note on commencing your appeals. All appeals, save for human rights and EEA appeals, now need to be commenced online. If you cannot do so for a particular reason, you can still commence without using the online procedure, but you must explain why it's not possible. We are then having, in all cases that have been adjourned and new cases, standard directions are being issued. And the intention is that there will be a case management review hearing by telephone or Skype, and that all current hearings are vacated, and that at that hearing it will be decided how the matter can and will proceed. There are some points to note from these directions. The first is a requirement that all witness statements and evidence needs to be sent electronically to the tribunal and to the respondent together with an appellant skeleton argument. That is to be done within 15 working days. They are coming out with specified dates on them, and in fact I have a few with specified dates of tomorrow. No one's obviously realised at the tribunal that tomorrow is in fact a bank holiday. You then have the respondent must serve a response to the appellant skeleton argument. That is to take place within 10 working days. If no response is received within the time limit, it will be assumed the respondent does not take issue with the submissions contained in the skeleton argument. And I think this is causing a problem for the Home Office. I understand that one or two that have come back from the Home Office simply say, we rely on the refusal letter. We don't agree with the contents of the appellant skeleton argument, which I don't think is really the intention of the tribunal in these directions. I think they want meaningful engagement. Those of you who are aware will know that these are very similar to the pilot project directions, where things are supposed to be front loaded. You're supposed to be trying to narrow issues at an earlier point, and just simply relying on the refusal letter will not be going down well. Once the documents have been sent in, a judge will consider them and will consider whether the appeal can be justly determined without a hearing, having given all parties an opportunity to make written representations on that topic. And where cases concern international protection, the appellant must set out a summary of the appellant's case with a schedule of issues, and there must be meaningful response in relation to those issues. Where it's not considered for the matter to proceed on papers and needs to proceed to a hearing, consideration will be given to the hearing of the appeal by remote means, and therefore there's various pieces of information that you'll need to have available. And the party must provide at the case management review hearing various pieces of information, including a bundle which may not exceed 50 pages. And I think there'll be a number of issues about that. In a lot of appeals, that's just simply not going to be pragmatic. It's also very clear that generic bundles will not be accepted by the tribunal. But as I said at the outset, we are awaiting further guidance from the first tier tribunal in respect of their practice direction. It's being held back at the moment. It was supposed to be out, I think, a fortnight ago tomorrow, and we still don't have a date when it will be released. So something to keep an eye on. Upper Tribunal, obviously they deal with both statutory appeals and judicial reviews. Just to cover those briefly, their operational guidance on HMTCS's website tells us that there may be some delays in processing non-urgent work, and that in relation to statutory appeals, they were being listed, those were listed for hearing, have all been postponed. They're all being judicially case managed. And what's effectively happening there is directions are being sent out, and they seem to be very keen to try and deal with anything they can, either on the papers or remotely if possible. But dealing with things by way of written submission seems to be the preferred choice at the moment. And of course, there are all sorts of issues that arise there in dealing with things remotely or on the papers without even a remote hearing. In terms of judicial reviews, non-urgent judicial reviews, it says they should be sent by post. That is what it still says on the update, on the operational guidance when I last checked. That situation has slightly altered. You can now send them by email as well. They're not going to be necessarily processed, but you can email them. The fees counter at Fields House is obviously still closed. We've got practice direction from the President in relation to how the Upper Tribunal are going to deal with work whilst the pandemic is with us. They remind us, I'm just going to go through a number of the relevant rules that may affect you in practice. They remind us that they do have the ability to deal with appeals without a hearing, but they will do so having taken into account the views of all parties, but they may do so without consent. And they indicate that as far as they're concerned, that will be the usual way to proceed. I don't know how far they're going to get with that, because I think there's all sorts of fairness issues, especially where people need to give evidence, and also in material error of law hearings dealing with issues such as responding to the judge and their views as to the merits of your application, because you may have no indication at all what the judge's position is. To the end of dealing with these matters, the judge will consider whether in all circumstances known to the judge, his or her provisional view is that it would be appropriate for the Upper Tribunal to decide the question of material error of law without a hearing, and whether the decision, firstly, whether there is a mistake, and then secondly, whether it should be set aside. If it's thought it would be possible to do so and just deal with it on the papers, you will be given an opportunity to make representations, firstly about those two questions, and secondly about whether or not it is appropriate for the matter to proceed in that way. And that's paragraph 13 of the rules there. Just to remind you that those directions that come out into paragraph 11 and paragraphs 11 to 13 do only relate to the question of material error of law. They do not relate to whether or not the appeal should be decided in a particular way if a material error of law is decided. If a material error of law is identified, there will be further directions regarding how the matter should proceed. And the tribunal indicates there's more likely to be a hearing, especially because there may need to be oral evidence and findings of fact made in some cases. If a hearing is necessary, the default option apparently is going to be remote hearings. That will include video links, telephones, and other instantaneous two-way electronic communication. I'm not too sure what they're envisaging there. Accordingly, no question in remote hearing is not a hearing for the purposes of the Upper Tribunal rules, but I don't think that's particularly controversial. In terms of documents, they've explained how they want them filed. You can send them by post, but you must also file and serve them electronically in advance of the hearing. And there's also some guidance in paragraph 24 about what they expect to be in those bundles. You don't need to file copies of judgments that are publicly accessible online. Citations will be sufficient. Equally, with background material, country evidence that's widely available, the extract and where it comes from will be sufficient. You don't need to provide the whole document. They're also expecting us to use our judgment as to what actually needs to be in that bundle that relates to the issues that are actually before the Upper Tribunal. Quickly, if you do have a remote hearing, you will have both a time and a date for the hearing. It won't just be a date, you will be given a time for that remote hearing, and there's just some information in paragraph 27 about how the tribunal will make the arrangements on the day. They emphasise at paragraph 29 that a remote hearing may still be suitable even if you do need to hear oral evidence, depending on the extent of that evidence. I think in reality there's going to be very few, if any, that can be dealt with in that way where oral evidence is required. But they do confirm in paragraph 30 that if a hearing is necessary, where all parties need to be present, then appropriate precautions will be taken in order to prevent the transmission of COVID-19, and arrangements will be made for hearings to be suitably dealt with. And if that isn't possible at the time being, it will be adjourned until such time as we can all safely go back to work. Just quickly on the rules in relation to judicial reviews. Paragraph 33 gives you the details as to where you can file urgent applications, where you need urgent or immediate consideration. No change to arrangements for urgent or immediate applications where the applicant is unrepresented. And if you need to use the out-of-hours court service, that remains the same. If it's dealt with without a hearing, your urgent application, you can still ask for a hearing. That will take place by telephone. the rules, again, still say applications for upper tribunal judicial reviews which don't require immediate consideration can still continue to be filed by post. There is now provision for you to file them by email as well. And just confirms there that they can't deal with judicial review applications on the papers in the same way that they can deal with statutory appeals. We did have this notice from the upper tribunal on the 29th of April. This came out, and that is the guidance which just confirms that you've now got the option to file your non-urgent judicial review work by email, which I think will make things easier. But just a point to watch, they now want online payment for those. You can't avoid making the payment at present. So online payment or cheques and postal orders if you're filing by post, and then cheques, postal orders, bankers, drafts, credit and debit cards will still be accepted once the fees counter opens. Okay, thank you very much. I think the agreement is we'll take questions at the end, so I will hand over to Adam.
Thank you, Emma.
Brilliant. Thanks, everybody. I hope you can hear me, and thanks, Emma, for that fantastic session. In my session, I'm going to give a case law update because I'm sure a lot of you have just been sitting at home, grossing out on Tiger King on Netflix and have forgotten all about immigration case law. So what I'm going to try and do is just remind you of some recent case law. And let me get my screen up, and I'm just going to share my screen, and then we'll start. Hopefully you can all see my screen there. What I'm going to do today is firstly give you some hot news off the press with some recent case law, and then we'll look at some other areas. Forgive my headphones and my microphone. I look like a teenager who's been stuck in his bedroom playing Fortnite, which unfortunately I haven't been doing, but let's give you some immigration law. So I noticed while Emma's session was going on in the chat that people cited about the no recourse to public funds judgment coming out today. And what I've done, I've put the summary from DPG law in the chat. Effectively, that was successful today on Article 3 grounds. If you want to have a look afterwards, do go onto my LinkedIn or my Twitter, and I've linked this DPG summary as well from there. And it says there, the judges ruled that the NRPF policy breaches Article 3 of the ECHR, which prohibits inhuman and degrading treatment. A detailed judgment and order will follow, which will set out the steps the Home Office needs to take to comply with the judge's ruling. So a significant ruling this morning that'll affect things going on. What about some other hot off the press stuff then? So two recent cases that I'm going to look at before we get into my main slides. The first thing is last week's judgment from the Supreme Court in Article 3 and health cases, the case of AM Zimbabwe. Again, another positive result there from the Supreme Court. AM, a deportation case. AM had some very significant criminal convictions. He was HIV positive, was on antiretroviral drugs, and they'd already had to be changed a number of times. And it was likely that he wouldn't be able to get the necessary antiretroviral treatment in Zimbabwe. He'd appealed on human rights grounds, and in the first tier tribunal and the upper tier, it had largely proceeded on Article 8 grounds. Now that was because at that time, N was still good law, and the advocates decided that it was unlikely the case would ever succeed under the N threshold. And we know the N threshold reduced Article 3 medical cases to deathbed cases. Could you die with dignity in your home state, and you're likely to die in a very short period of time? Now, N had in fact gone up to the European Court of Human Rights, and in the European Court of Human Rights, they had talked about other very exceptional cases. And it was only when Paposhvili was decided that gave some guidance as to what were these other very exceptional cases. And Paposhvili talked about those who faced a real risk in the receiving country of being exposed either to a serious, rapid and irreversible decline in health resulting in intense suffering, or to a significant reduction in life expectancy. Now, this had been raised by the appellant in the Court of Appeal, but the Court of Appeal had found that they were bound by the House of Lords decision in N, and they gave a very restrictive sort of interpretation to Papashvili in any event. So the case went up to the Supreme Court, and the Supreme Court decided that now was the time to depart from N, and that Papashvili does expand the test beyond deathbed cases to where there is a real risk of intense suffering or a significant reduction in life expectancy. And they also found that the Court of Appeal's interpretation of what was a significant reduction in life expectancy was too narrow. The Supreme Court also gives some guidance on the sort of evidential process, and where an appellant is able to adduce evidence capable of demonstrating that there are substantial grounds for believing that they would be exposed to a real risk of treatment contrary to Article 3, the burden then shifts to the Respondent Secretary of State to dispel any of the doubts raised. Obviously, it's quite a high threshold on the appellant in terms of what evidence is required, but helpful in terms of the evidential analysis as well. So in health cases, we're no longer restricted to the very narrow approach of N. Although I would say it's still a very difficult test, and you may want to consider also advancing Article 8 in your health cases, and look at 276 ADE and whether you can advance the very significant obstacles to integration in terms of health cases. But certainly Article 3's got more purchase now in the light of AM Zimbabwe. The other hot off the press case is the new country guidance, AS, Safety of Kabul, Afghanistan, which came out on the 1st of May. You may have remembered that the previous country guidance had gone up to the Court of Appeal, and the Court of Appeal had found they'd made a statistical error and remitted the matter back to the upper tribunal. Now, this case looks at the position in Kabul in terms of the risk from the Taliban, and a person of low-level interest for the Taliban is not likely to be at real risk. They also looked at Article 15C, and the risk of serious harm in Kabul. And they find at 2 of the head note there is a widespread and persistent conflict-related violence in Kabul. However, the proportion of the population affected by indiscriminate violence is small and not at a level where a returnee, even one with no family or other network and who has no experience of living in Kabul, would face a serious and individual threat to their life or person by reason of indiscriminate violence. So no general Article 15C risk. What about the reasonableness of internal relocation to Kabul? Because that often is the key question that comes up. Roman 3 of the head note says it's not normally unduly harsh for a single adult male in good health to relocate to Kabul. But Roman numeral 4 is really important. However, the particular circumstances of an individual applicant must be taken into account in the context of the conditions in the place of relocation. And they give a list there: person's age, quality of support networks, physical and mental health, language, the time they've been out of the country, employment opportunities. So all these things you'll want to address in your Afghani cases. And then in Roman 5, they go on to look at support networks and somebody's familiarity with Afghanistan, because often in Afghani cases, children come over, they get leave as an unaccompanied minor, and then they're going back as an adult with no recent experience of living in Afghanistan. At the end, they do confirm which parts of the previous country guidance, in particular in relation to women and the risks there, are still relevant and are still to be treated as country guidance. So have a look at that. Let's move on to the main parts of my notes then. So we're going to have a look at Article 8, we're going to have a look at asylum, we're going to look at EEA, and then we're going to look at deportation, and then Emma will come back and we'll address some of the questions in the chat, and I'll aim to finish by about 25 past 1 to leave 5-10 minutes for questions. And what you can do is, I've emailed out the slides, I've also put the slides in the chat, and they're on the Number 8 Chambers website. So have a look at them. You'll be able to lift some of the stuff from our slides and use them in your representations, use them in these all-important appeal skeleton arguments, which are becoming, I think with the stuff that Emma's talked about, our written representations and skeleton arguments, with more and more cases being dealt with on the papers, are becoming more important and key that we address the key issues in our written documentation. And the first case I want to address is the case of Eunice. It's not a very good case, and I think it raises some serious legal problems. If there's any Home Office presenting officers on the call today, please don't read Eunice. It's not a helpful case. You don't want to read that. In this case, the appellant was a Pakistani national, but she lived the majority of her life in Dubai, and she entered on a visit visa in 2016 to come to be with her partner, her British partner, and she was pregnant at the time. And soon after, she gave birth to her British daughter. The British partner had 2 minor British sons from a previous relationship. In 2018, she applied as an overstayer for leave to remain, and that was refused. And the case went up to the upper tribunal and came before a presidential panel. And in the upper tribunal, the Secretary of State accepted, and this is crazy when you look at what the outcome is, accepted that there were insurmountable obstacles to the appellant's family life continuing outside of the UK, and it would not be reasonable or proportionate for the family unit to be indefinitely separated. Now you'd think, wow, with those concessions, we're home and dry. But what happened in the upper tribunal? Well, the upper tribunal found that the appellant and her partner had exaggerated their evidence, particularly in relation to her extant connections in Pakistan and to the partner's financial situation. And the upper tribunal found that it was more likely than not that the partner would be able to meet the financial requirement, or would be able to do within a short period of time. So if an entry clearance application had to be made, it would only take 4 to 9 months. Therefore, if the daughter went with mum, who was the primary carer, they would only be out for a limited period of time. The upper tribunal found that the requirements of Appendix FM could not be met in country, because obviously she couldn't switch as a visitor. Emma's already addressed the COVID issues with switching. And then the upper tribunal addressed the Chikwamba argument. Now the Chikwamba argument is, well, what's the point in insisting on making an entry clearance application if we can meet the entry clearance, we can show we meet the entry clearance rules here. Now remember, for Chikwamba to bite, you've got to show that you would be successful in your entry clearance application. Look at the case of Core, look at what's said in Agiarco. So you need to be able to show, before you even get past go, collect your £200, that you meet the requirements of entry clearance. But they said, well, that's not the end of the matter. So look at this on your screens from Headnote 1, an appellant in an Article 8 human rights appeal who argues that there is no public interest in removal because after leaving the UK, he or she will be granted entry clearance, must in all cases address the relevant considerations in Part 5A of the 2002 Act, which stipulates the maintenance of effective immigration control is in the public interest. Chikwamba doesn't obviate the need to do this. And they found that her immigration history was such, coming on a visit, overstaying deliberately to be with her partner, to outweigh the fact that she met the rules. And they talk about Chikwamba, and that even in Chikwamba, Lord Brown talked about there being exceptions. Now, I think this is a stretch too far, because if you look at the exceptions in Chikwamba, they were cases such as Akinci, which had an appalling immigration history and made up repeated false asylum claims. This client wasn't in that position, but the upper tribunal find that in this case, the public interest outweighs the Chikwamba issue. They went on then to consider section 117B6, and that's where there's a qualifying child. It wouldn't be in the public interest, where it wouldn't be reasonable to expect the child to go. Now we know when we consider that, we must always have the hypothetical assumption that the child will go, see AB Jamaica and JG cited in paragraph 2 of the head note. But then when you're actually considering the reasonableness, they say, well, you move from the hypothetical to the real. And the real circumstances in this case is the child will only be out of the UK for 4 to 9 months. Now, I've got a problem there because I think that's hugely speculative. We all know the real situation when somebody goes and has to apply for entry clearance and how long that can last in reality. So I think there's a bit of contradictory reasoning there within the upper tribunal's findings. But what the tribunal will apply now, looking at the head note of this case, is, well, we'll look from the hypothetical to the real. How long will this child actually be outside the UK? Another argument that was raised was the Zambrano argument. Well, the child will be deprived of their genuine enjoyment of their rights as a European citizen, a British citizen in these circumstances. But they say, well, again, even with Zambrano, we look at the actual facts rather than theoretical possibilities. And the actual fact is she won't be deprived because she'll only be out for a limited time. Again, I think that's hugely speculative and contradictory. And it introduces a sort of sliding scale into Zambrano, which I don't think is there in the Court of Justice case law, but they found that Zambrano doesn't assist in this situation, and they dismiss the appeal. So a really difficult judgment, which has some contradictory reasoning in it. Now, I've spent a lot of time talking about that, so we'll need to speed up as we go through. Let's look at a case called Rema. And this again centers around 117B6 and the reasonableness question. Again, Mrs. Runa entered in 2006 as a visitor. She overstayed and in 2014 married a British citizen, made an application as a partner, and while that was pending in 2015 had her first British son. Her case came before the first tier tribunal, who allowed her appeal. The Secretary of State appealed to the upper tribunal, and during that time her second British son was born. In 2019, the case came before, as he then was Deputy Upper Tribunal Judge Mandalia. He found an error of law in the decision of the first tier tribunal, and then he re-decided the appeal and dismissed the appeal, finding that it was reasonable in this case for the child to go. And when he looked at the appeal, what the deputy judge did is he looked at a couple of questions. He looked, well, could the children stay with dad in the UK? Or could the whole family go to Bangladesh? And he said, well, there's no insurmountable obstacles to husband going. So if there's no insurmountable obstacles to husband going, it would be reasonable for the whole family to go. The case came before the Court of Appeal, looking at the construction of Section 117B6, and the appellants argued there that where one parent has a right to remain, it would never be reasonable for a British child to have to leave. What did the Court of Appeal say? Well, a couple of things. Firstly, look at paragraph 32 on your screen, and it's quoting the Counsel for the Secretary of State, where it says he submits that Section 117B6 is to be regarded as a benevolent provision, which can only operate in one way, potentially in favour of an appellant, but never adversely to an appellant. What does that mean? What it means is if you meet Section 117B6, your appeal should succeed. But if you don't meet Section 117B6, that's not the end of the matter. As paragraph 33 says, still a proportionality assessment has to be made. So even if you don't meet 117B6, there still may be other reasons why you should succeed when weighing the whole of the proportionality assessment. Now in Runa, the Court of Appeal rejected what the appellant's primary submission was, that you should always succeed when one parent has a right to remain, but they accept the alternative submission that in each case there has to be a proper fact-finding exercise to answer the single question whether it be reasonable to expect the child to leave the UK. And remember, that focus is on the child. We know that from KO Nigeria. It's not a balance, the focus is on the child. So they found in this case that the deputy judge had asked the wrong question. He'd asked the questions, well, could the family stay? Or could the whole family go? He didn't ask the proper question of whether it be reasonable for the child to go. And that's not a question of insurmountable obstacles. Reasonableness is a different question. Even when you're assessing proportionality, the test is not insurmountable obstacles. And they say GM Sri Lanka, which we'll come to in a moment. So that's a helpful case on 117B6. And there'll be some paragraphs there you may wish to cite in your arguments. Let's press on quickly. Udin is a useful case. A lot of you may deal, we'll go back to Afghan children, with say Afghan children who come over, make an asylum claim, that may be refused, but they get leave as an unaccompanied child. When they reach majority, they apply for that leave to be extended. And then there's an appeal on their case, which when they may rerun their asylum appeal, and there'll also be an Article 8 assessment. And often it involves the relationships that are built up, particularly say with foster carers in the United Kingdom. And that's exactly what happened in this case. Udin was 20 when the case came before the Court of Appeal, but he'd initially been found as a child abandoned in London, given leave as an unaccompanied asylum seeking child, placed into foster care, and he applied for an extension of his leave. His asylum claim was rejected. He appealed, and the appeal focused on Article 3 and Article 8. And very much in the first-tier tribunal, the judge focused on Article 3. And she rejected the credibility of his historical account and used those credibility findings to disbelieve him effectively on everything. And I've put on your screen here, paragraph 11 of the judgment, and this will be really helpful for you, maybe in drafting grounds of appeal, but also where you're advising on a case where there's perhaps an asylum element and an Article 8 element. And this is the fact that just because somebody may be untruthful about one matter, say the history of the case, it doesn't mean they're being untruthful about another, say the existence of family life. In the Crown Court, in criminal cases, this is what's called a Lucas direction. A judge will give a jury a Lucas direction, that they must look at each part of the claim separately. And just because you've lied about one bit, there's different reasons for lying, doesn't mean you've lied about another bit. So that's very helpful, because what happened is the judge rejected Udin's credibility and then didn't make proper findings on the family life. When the case came before the upper tribunal, the deputy upper tribunal judge, and I'm sure many of you have seen this in refusals of permission or refusals to find an error of law. Oh, well, this judge was very experienced and they made a meticulous and balanced assessment of the evidence. Now, yeah, we give first-tier judges respect because they are specialist judges, but it's not implied that they won't make an error. And the Court of Appeal criticised the deputy judge for just assuming a judge wouldn't have made an error just because they're experienced. And in all other respects, it was a detailed judgment. So again, you'll want to cite that. Perhaps when you are renewing your grounds and you've been told, oh, well, this was a meticulous judgment by an experienced judge, you can use that to say, well, that's irrelevant. The judge has still made a series of errors. So they found that the judge had not properly assessed the family life, and there was uncontested evidence from the local authority, from the foster family, which showed there was this additional level of dependency. And you know that needs to be found in adult Article 8 cases, going back to the case of Cougarthus. The deputy judge in the upper tribunal had introduced this idea that foster carers were commercial arrangements, and that therefore put them in a different situation, the Secretary of State argued before the Court of Appeal. So the Court of Appeal, and I'll go quickly now, look at Cougarthus dependency, and they say it's a question of fact, and is there committed or real or effective support? That's what you're looking for. There is no test, paragraph 32, of exceptional dependency. Everything is fact sensitive. And foster carers are not in a special category. So if you're arguing a case of family life with a foster carer, that doesn't put them in a special category. And they go on to say there is no assumption that just because somebody's reached adulthood, no assumption positive or negative in relation to family life. So that doesn't mean just because he's now an adult, the family life is extinguished. And look at the end of paragraph 36. Continued cohabitation will be a highly material factor to be taken into account, and while not determinative, a young adult still cohabiting with a family beyond the attainment of majority is likely to be indicative of the continued bonds of effective, real, or committed support that underpin a family life. So that's worth its weight in gold in terms of adult family life relationships. Paragraph 40 is a useful summary of what I've said. So no exceptional dependency test in terms of Cougarthus. Foster care is not in a different situation. It's a factual assessment. Majority doesn't create a presumption, and you look at this continued cohabitation. Is there real and effective committed support? Now, I said about GM Sri Lanka earlier, and that was looking at these precarious relationships with overstayers, or relationships that have been formed when somebody's here precariously. Also look at the case of Lal. I'll briefly touch on GM because GM's a really helpful case. Miss GM had formed a relationship with her partner while she was on student leave. Her partner had discretionary leave under the legacy scheme, and the couple had 2 children. And I think when their case was before the first hearing in the upper tribunal, the partner and the children still had discretionary leave under the legacy scheme. Later on, they got indefinite leave, and by the time the case came before the Court of Appeal, they'd had a 3rd child who was a British citizen. And just a couple of things from this, that when we look at Article 8 outside of the rules, you don't have to show some test of exceptionality. There's no special test, and you don't have to show a highly unusual or a unique factor. Paragraph 29, it's a proportionality balance. Now, don't think that means it's an open goal. If you don't meet the rules, that's going to weigh against you. But often we see the Secretary of State arguing, and we see judges writing decisions, applying a test of exceptionality or looking for a highly unusual or a unique factor. It's all about the circumstances of the individual case. Paragraph 30. Now, before I go on to paragraph 36, you'll just also want to jot down, have a look at paragraph 34, which is about the nature of the rights that the partner would have to give up. You'd have thought in this case, because the partner only had discretion leave under the legacy scheme, that didn't amount to much. And that's perhaps what the first tier tribunal thought. But actually the Court of Appeal said, well, actually, the legacy scheme is a path to settlement. Therefore, his rights should have been given more weight in the balance. So that's really helpful. And also look at paragraph 42 and following, where they look at the best interests and the paramountcy of interests of children. In terms of the little weight provisions in 117B4 and 5, the judge in this case had wrongly given little weight to their family life. But they had leave when the relationship was formed. Their status was precarious. But in section 117B, it doesn't require little weight to be given to family life when leave is precarious, only to private life. So that was an error. So it's an important distinction which you want to bear in mind. And they also look at insurmountable obstacles. Insurmountable obstacles under EX1B is the test. So if you're going to satisfy EX1B, that is the test. But outside the rules, it is not the test. Look at paragraph 48. It's simply a relevant factor. All right, let's jump to asylum. I've got 10 minutes left. I'm going to try and cover 3 more sections in 10 minutes. Here we go. Looking at asylum, the first thing I want to deal with is religious conversion cases. This comes up in the context of Iran and the new country guidance in Iran. Have a look at paragraphs 117 to 140 of PS, and the country guidance is given at 141 to 144. And this applies to conversion cases and replaces other country guidance. And it says this: decision makers should begin by determining whether the claimant has demonstrated that it is reasonably likely that he or she is a Christian. If that burden is discharged, the following considerations apply. So the issue is often going to be now the genuineness of the conversion. Would they seek to openly practice their faith? If they would, they'd be at a real risk in Iran. 2, if the claimant would in fact conceal his faith, decision makers should consider why. Now, this applies wider than just the Iranian context and wider than just the Christian context. If any part of the claimant's motivation is fear of persecution, the appeal should be allowed. So this is the H.J. Iran principle, that if any part of your motivation for behavior modification is to avoid persecution, you shouldn't be excluded for refugee status. But they say if the claimant would choose to conceal their faith purely for other reasons, they could practice in private. They also go on to look then about non-genuine converts, people who pretend to convert, and the whole Danian point. Now, there wouldn't be a risk on return if you're not genuine in terms of in-country, but there may be a risk at the pinch point of arrival. And a lot of you will be aware of the case of AB Iran, which looked at internet activity. But this here talks about there being questioning on arrival. If you say you've claimed to be a Christian, you might get more questioning. And if actually there are reasons why your detention would be prolonged, that would put you at risk. And one of those reasons that might prolong your detention is social media activity, which is often a big issue in our asylum cases today. In terms of evidence from church witnesses, the court has just given the case of MH. The first 3 parts of the head note are to do with the powers of the tribunal, where a judge effectively cocks up and all their determination means to dismiss an appeal, and at the bottom they say they allow it, or vice versa. And this talks about the toolkit of powers in terms of setting aside and the FTT reviewing decisions and setting aside obvious errors. So if you've got one of those cases, look at this about when you're formulating your grounds and ask for it to be set aside. But they say at Roman 4, written and oral evidence given by church witnesses is potentially significant in cases of Christian conversions. And they talk about the Scottish case there, TF and MA, which is very helpful. Such evidence is not aptly categorized as expert evidence. They disagree with TF and MA in that respect, nor is necessarily deserving of particular weight. And the weight to be attached to such evidence is for the judicial fact finder. But if you look at the judgment in this case, they set aside the decision of the first tier tribunal very much because they hadn't properly considered the evidence of the church member. And I think the tribunal had only rejected it because she didn't know about the client's previous asylum claim. In terms of, we're seeing a lot of cessation of refugee status claims at the moment where somebody's committed, often Somali nationals, where they've committed criminal offences, and there's issues about whether they've can be returned to Somalia. MS, which was done by Emma and Stephen Vokes, the head of our immigration team, found that there's a mirror image approach in the cessation of refugee status. And that means if a relocation alternative is available in the country, even though you still may be at risk in your home area, refugee status can be revoked. Have a look at the summary by the upper tribunal in SB Somalia. That also looks at the proper interpretation of MOJ, the Somalian country guidance. Let's jump to quickly some EEA. We talked about Zambrano earlier. Zambrano is going to be continuing significance because under the EU settlement scheme, we know we can now get settled status for those with derivative rights where we previously couldn't get a permanent right of residence. The Supreme Court reviewed the Zambrano jurisprudence in Patel. Patel considered an adult carer for his parents, where there was also the linked appeal of Shah, and Shah was looking at somebody who cared. Father was the primary carer for a British child, but there was a British citizen wife, Mrs. Shah. Now, what lies at the heart of the Zambrano jurisprudence is that the EU citizen would be compelled to leave the EU if the third country carer had to leave. Paragraph 22 says that. And they look at this case called KA, and there's a real distinction drawn between adult carers and carers of children. And they look at Chavez Vilesh, and Chavez Vilesh doesn't relax the compulsion in adult cases. So adult cases are only going to succeed exceptionally. and Patel failed. But Shah was successful. Dad was the primary carer, and the Court of Appeal were wrong to say, well, Mrs. Shah has a choice. So effectively, the child and Mrs. Shah could stay. No, the issue in this case was Dad was primary carer, and if Dad went, the child was likely to follow. Therefore, the case was successful. So that's worth having a look at. Tough on adults, but helpfully in terms of children. Chen children can rely on the unlawful earnings of their parents. That's the case of Bajratari. That does what it says on the tin, so I'm not going to go into that in any more detail. ZA, in terms of Surinder Singh, is really helpful. It's ironic, as sort of Surinder Singh comes to an end, we see liberal sort of decisions from the upper tribunal, but there's no requirement to transfer centre of life to the host member state. And it also looks at the intentions, and the intention has to be to exercise genuine treaty rights. And there doesn't have to have been integration into the host state. So really good judgment in Surinder Singh. So if you've got a Surinder Singh case, look at ZA. Retained rights. This was a case where a guy had divorced from his EU citizen partner. Previously, he'd been given a residence card. He was now applying under retained rights. They accepted that Regulation 10 was satisfied, but the only reason it was rejected is because he couldn't submit his ex's passport. And the upper tribunal very helpfully reviewed the case. They note that he'd previously been granted. They said, look, Regulation 42 hadn't been properly looked at, where there was a discretion. And they say here, in some cases, this might involve ignoring the requirement for specified evidence altogether if a document is not in fact required to establish a right of residence. So again, really helpful. And actually, if you want some general background sort of summary of how to interpret EU law, which will be useful for your appeal skeleton arguments, have a look at Rema. Useful. Finally then, in the last minute or two, deportation. Unduly harsh. We were all excited when we got KO Nigeria in terms of deportation, that when we're assessing undue harshness, the focus is solely on the child, or where there's a partner, just on the partner. And we thought that we'd be more successful in unduly harsh cases. But what we've seen is the Secretary of State appealing all those cases that we've been successful on undue harshness, and the Court of Appeal overturning them. And there's a real ramping up of the undue harsh test. The two cases I've cited, we've got this one here, PG Jamaica, and this one, there was 3 British children involved, and even though they would suffer great distress, that wasn't enough. And look at this, many parents of teenage children are confronted with difficulties and upsetting events of one sort or another, or have to face one or more of their children going through a difficult period for one reason or another. And the fact that a parent who is a foreign criminal will no longer be in a position to assist in such circumstances cannot itself mean that the effects of his deportation are unduly harsh for his partner or children. So you're going to need to show that something extra when preparing deportation cases and arguing undue harshness. This has been picked up from the upper tribunal in Patel. So just because you've got a British child doesn't mean it's unduly harsh. And again, in Imran, another recent case, and you've got to show that something more. Without more, it's not going to be enough that just because there's a separation of one parent from the child. So think about the evidence you're producing. Think about getting your social work reports and front loading the case to show that this is a case with something more to raise it into that undue harsh test. Although, remember, undue harsh is not exceptionality. So the courts mustn't go down that road. It is a lesser test than that. In terms of the public interest in deportation, it can be a movable public interest. This was a case of a client who'd lived here all of his life since 1983, born here, was entitled to British citizenship, but never had taken it up, had some serious criminal offences that got him into the over 4-year category. But the Court of Appeal said, well, there has to be a flexible approach to the public interest, and there may be an exceptional few cases where the public interest will be reduced. And this was one of those cases. He'd lived here all his life, was previously entitled to British citizenship, and had mental health problems. They also confirmed the enduring relevance of the Hesham Ali and the test to the public interest there. So well worth having a look at. The last case before we stop for 5-minute questions is CI Nigeria. That was to do with somebody being integrated socially and culturally, to do with exception 1 in deportation. And sometimes where somebody's been in prison, it'll be argued, well, they're no longer socially and culturally integrated to the United Kingdom. But just because you've been to prison doesn't mean your social and cultural integration has been broken. And sometimes judges approach it like that, and that's an error. So look at paragraph 77. I've already used this paragraph in grounds, and we've got permission on that basis. This case is also good as it confirms the ongoing endurance of the Maslow test for the sort of settled migrants who've lived here most of their life. It's 1:25. We've got 5 minutes for questions. Hope that wasn't too fast for you and that's helpful. Do lift some of these paragraphs up and put them in your representations and appeal skeleton arguments. I'll hand back to Bushra now, but I'll leave my microphone on for Emma and I to answer some questions. Thanks, Bushra.
Thanks, Adam. That's really, really helpful update on case law. I'm just going to pull up. Emma, do you want to bring yourself back up now? We can go through the questions. Let me just pull that up there. Great. So we've got a really helpful comment from Mohammed Amjad there. Note with language tests, you can submit an application, get a window of around 6 weeks to provide your documents, and this can be extended further if necessary. You can utilise this to do your test. You could also ask the Secretary of State to put consideration of your application on hold so as to have sufficient time to meet the requirements. Was there anything that either of you wanted to add on that?
No, I mean, as I said when I was in my talk, obviously you've got the option of being asking for more time and putting your application on hold. It's going to be a problem, I think, for a lot of people for some time because there's going to be a backlog of people needing to take tests. So it's just something to be aware of when making applications, I think.
There's a question from Simon Woodhouse there on switching in country. Do you think a visitor and fiancé could apply in country under Appendix FM? Fiancés usually cannot apply in country.
Well, the switching guidance isn't limited to tier-based applications. When you look at where it is in the guidance that they've issued, it's in a general document that covers a number of different situations. So I think it would apply. The visitor would obviously have to, or the person would have to be in the country at the moment. It's obviously only applying to those who can't leave at present to go and make the application. But I think it would be a possibility. The Home Office may take a different view, but I think the way they've drafted their guidance, it covers any application where you'd normally have to leave the country to make it.
Thank you. A question from Tamanna Aziz. Does limitation on working for students working with private care homes still apply?
At the moment, from what I've read, it seems to suggest NHS, but I think there'd be arguments that it should be extended. I'd have to check that point, to be honest. There's been quite a few changes on where you can work. I think I did see something that suggested if you're with a healthcare provider, but I would need to check that point.
Thank you. A question from Nergis. Will the lifting of the no recourse to public funds restrictions and from 5 years into 10 years be transitioned into non-COVID future cases?
I think if what you're asking me there is that would it affect the switch from being forced off the 5-year route onto the 10-year route in non-COVID cases? Well, that's the problem that we have, is that's the usual position, that if you apply for no recourse to public funds condition to be lifted, you're usually transitioned onto the 10-year route because you're not complying with the terms of the 5-year visa. And it would apply in all cases. The issue I think that's being raised is that those who are needing to apply in relation to COVID, it's perhaps a little bit unfair to force them onto a 10-year route. But the standard, as I understand it, standard procedure would be if you applied for other reasons, you'd end up on the 10-year route to settlement.
Thank you.
I don't know if the new case will deal with that at all. That seems to be on different lines looking at the summary, but maybe there'll be some helpful stuff. And obviously the Home Office are going to have to go back and rewrite things in the relight of the new case. But I think that is an issue where it's still very much early days and evolving as to what's going to happen, definitely. But I agree with Emma in that respect.
Thank you. And then I think we've got a final question there from Mohammed. To what extent do you think the ministerial statement that no one will adversely suffer as a consequence of COVID-19 can be relied upon on a more general basis to potentially found a legitimate expectation, especially in areas where no formal concession or relaxations have been made. For example, the 30-day visa holders now get a free extension, but what about a returning resident who ends up staying abroad for more than 2 years as a result of COVID, planned to return before secondary anniversary, but then there were no flights? I've been contacted by someone who's had a flight booked to return just before the second year anniversary, which didn't then take place.
I think the ministerial statement, and I can't remember if it was any Emma's slides or not, it was very early days. I've put it online previously, and then if anybody hasn't got the link, do drop me a line and I'll get it to you. But I think it's well worth citing, and it does apply in a wider context. Whether it could found a legitimate expectation, the court's jurisprudence on legitimate expectation is always very narrow. There's got to be a sort of an ambiguous promise. Whether we could stretch it that far, I don't know, but certainly I think it would be worth citing and having a go in those wider cases where there hasn't been a specific concession, and certainly it must significantly reduce the public interest in any Article 8 proportionality assessment, certainly. But yeah, I would, that ministerial statement that I circulated, it would certainly be worth citing in a lot of your representations, that nobody would be prejudiced by this. So yeah.
The other thing to remember as well is, of course, paragraph 20 of the immigration rules does give a discretion if you're over the 2 years and you've got significant ties to the UK. So yeah, Adam's absolutely right. Rely on that ministerial statement and rely on paragraph 20 as well. You should be allowed to come back in those circumstances. It would seem unconscionable not to allow you back, but whether you've got a legitimate expectation, I think I'd be wary about relying upon that, bearing in mind the jurisprudence we have on that and how limited it is.
Thanks, Adam. Thanks, Emma. That's really, really helpful. Thank you for all for taking part. We do hope you found the session helpful. This session has been recorded and will be available both on Adam's website as well as the Bushra Ali group YouTube, both channels there. Please do access those, and please do remember number 8 chambers, business as usual, counsel available there to assist in skeleton arguments, advice and grounds. Feel free to contact the clerks there for assistance. Stay safe and look after yourselves, and thank you so much for taking part. Thank you.
Thanks everyone.
Thanks everyone.
Thank you.